Hi everyone, my name is Benedict Xiaosong Kai, and today I will present to you about the comparative studies of the different construction standards form of contract on the clause of delay and extension of time during MCO in Malaysia. So for the introduction, this study is to carry out the current contractual issue made by all the construction players in this MCO, which is the Movement Control Order. So in this study, the PAM Contract Form 2018 and PWD Form 203A, and also FIDIC Red Book 1999, and also the last one is the CIDB 2000 contract form will be compared. So to have a further understanding in the actual working side, a case studies of the SSP line, Mass Rapid Transit 2, as usually called as the MRT2 project, will be analyzed and investigate to gather the consequences and action taken by the project team in the MCO. So what is MCO? It is an implementation of Malaysian government to prevent and minimize the spread of the coronavirus. And the National Security Council of Malaysia has allowed the construction works may be proceeded with the approval form from the Malaysian Public Works Department, JKR, and also the Department of Occupational Safety and Health, DOSH, only if the delay of works will affect the public safety and security if they are not continued. Although it's allowed, a strict health protocol like body temperature checking, maintaining social distancing, and hand sanitization are needed to be compiled before entering the site. Due to this current situation, a specific laws need to be enacted in the construction industry to provide a legal shield for the construction parties. This should offer legislative protection to contractors from legal consequences arising from failure or inabilities to perform their contractual obligation and scheduled performance during this period. So as in the case study of MRT2, the SSP line is the second line of the KV MRT project to be developed, and it serves a corridor stretching from Kawasan Damansara to Putrajaya. So the alignment will have a line consisting of 44.2 km of elevated tracks and 13.5 km running through underground tunnel. Due to the restriction of MCO, MMC Gamuda, the main contractor of the MRT2, should take action to request for the continuation of the works. JKR and Dodge has classified the MRT2 construction as works as critical to public safety in their letter date at 31st of March 2020. So critical work like tunneling in project will continue as per government directive and all associated personnel are required to work during the MCO, because the tunneling works is the critical works that will affect the public safety. So the overall construction of the MRT2 is more than 70% complete, reported on the date of 11 March 2020. This is before the MCO. So this MRT2 construction included the tunnel boring works which underpass the Kuala Lumpur-Seremban Expressway near Sungai Besi. Although these works are continued, the completion of the tunneling works, which has achieved 85% of completion in the early March. This project is forced to be delayed until 17 July of 2020. Due to the MCO, the whole construction progression has been delayed from the expected completion date from July 2022 to January 2023. The extension of time has been granted by the MRT Corporation to MMC Gamuda due to the delay are not caused by the main contractor's negligence or professionalism, but the global COVID-19 pandemics. The terms of force majeure clause, which has been stated in all four contract forms, can be considered in this situation for the contractors to legally apply for the extension of time needed. So in the contract forms comparison with court cases, all contract forms are having different clauses in the delay and the extension of time. So in PAM, clause 23 has stated that is the extension of time. So in PWD, clause 43 is stated is delay and extension of time. So in FIDIC, it is in clause 8, the commencement, delay, and suspension, and also the clause 19, force majeure, and also the clause 20, the claim, dispute, and arbitration. So in the last one, CIDB, is stated in the clause 24, delay and extension of time. So the MCO is the efforts of the Malaysian government which is compelled to contain and control the COVID-19 outbreak. So MCO existence is not the underperformance or negligence of the contractor. It is an event of force majeure, which has the meaning of an extraordinary event beyond the control of both the parties from fulfilling their contractual obligation, and this COVID-19 pandemic can be considered under this clause. There is no general rule as to what constitutes force majeure, but whether such a force majeure event arises and where does it arise. The rights and obligations all depends on the contract which both parties have agreed with. So in section 57, number 2 of the Contract Act 1950, it recognized the doctrine of frustration rendering a contract void if performance of the contractual obligation becomes impossible by reason of some uncontrollable event. So every contract forms have different definitions of force majeure. In PAM, it defines force majeure as any circumstances that beyond the control of the contractor caused by the epidemics. The COVID-19 outbreaks, which has been declared a global pandemic, is likely to be regarded under such contract as a force majeure event. So in PWD, it defines force majeure by listing out the events which will trigger the application of the clause. It appears that the COVID-19 outbreaks and the MCO does not fall within the list of events expressly provided under clause 57.2, and the said clause appeared to be an exhaustive list. Then the Malaysian Ministry of Finance has later expressed that the COVID-19 outbreaks fall within the force majeure clause under the PWD form. They further provide that those contracts without a force majeure clause, the Malaysian government would still be able to use the principle and procedure of force majeure to deal with the issue of delay of the project. So for the contracts with a force majeure clause, the government may be interpreting the non-exhaustive list of events and either party will be able to apply. So in FIDIC, the force majeure is also referred as exceptional event in FIDIC form, and it defines as an event which is beyond the control of both parties, and the events are unable to be reasonably foreseen and avoided by the parties. The relevant clause in both standard forms then provide a list of events with the qualification that the relevant to the exceptional event has to be satisfied the above event. The COVID-19 outbreaks or the MCO can be referred as one of the events listed in the exceptional events. So lastly, in CIDB, it is stated delay caused by force majeure is allowed for the superintending officer to extend the time for completion. It is also stated that lockdowns can be considered as a force majeure event. So as you can see, the MCO is an lockdown. So in the explanation of the extension of time, in PAM, the contractor shall give a written notice to the architect to his intention to claim for EOT, together with the initial estimate of EOT and particulars of the clause of delay within 28 days from the commencement date of the event. The PAM form stated that such written notice is a condition precedent to the contractor's entitlement of EOT. Within the 28 days of the end of the cause of delay, the contractor shall send to the architect the particular of its EOT claims together with the necessary calculation and documents to substantiate the same. If the contractor failed to submit such particular to the architect, he shall be deemed to have assessed that the cause of delay will not delay the completion of the works. So in PWD, the contractor is required to inform the other parties immediately of the occurrence of the delay with full particulars and consequences. The contractor shall also provide a written notice to the superintending officer as to the cause of the delay and the relevant information with supporting documents so that the officer can determine the length of the delay and grant the appropriate EOT to the contractor. And in FIDIC, the contractor shall provide notice of exceptional event has been given. So the notice is to be given within 14 days after the affected parties became aware of the exceptional event. If the exceptional event has continuing effects, the contractor shall give further notice describing the effects every 28 days after the first notice. So if the contractors fail to do so, the other party may give notice to the contractor stating that the employers considers that the contractor's performance is no longer prevented by the exceptional event with reasons. So lastly, in CIDB, the contractor shall notify the SO of the event of delay and the estimated EOT within 30 days. The SO may require the contractor to provide further information of the event if the submitted notice is not sufficient. The SO shall also give the certificate of the EOT to the contractor and a copy to the employer. So as a conclusion, delays in construction activities have given a rise to the need of the application of the extension of time, providing more time to complete the projects. Unfortunately, the sudden impact from the COVID-19 pandemic has heavily challenged the construction industry. So most of the construction works are put to a pause due to this situation. And so delay are meant to happen and all affected contractors must take action to claim the extension of time in order to complete their works. With this research, different contract forms are compared to define and contrast the clauses in order to ensure all contractors will be legally allowed the EOT with the reasonable clause. And so that's all for my presentation, and thank you so much for listening, and thank you and bye.